So in our last video, we looked at the rules that establish relevance, 401 and 402. And they establish the fairly obvious abstract notion that those things which are relevant are admissible and those things which are irrelevant are inadmissible, subject to certain other constraints like Fourth Amendment exclusionary rule or privileges or other things we'll come to later in the class. But we're looking at that at a high level of abstraction. We saw the rule, and we'll go to the rule. Actually, I'll share my screen and take us there. Share. And that takes us back to chart, of course. And we'll go to relevance, and we'll look again at 401 and 402. And there we see that, of course, a rule evidence is relevant if it has any tendency to make a fact more or less likely, and that fact has to be of consequence. But we want more than that. We want some sense of what this abstract principle looks like on the ground. So as you do in all your law school classes, we're going to look at specific facts. And this is the case of State versus Newman, the very first case you'll read in charter course. And in People versus, or rather State versus Newman, the question in this case is whether a defendant who is accused of DUI has the right to present the testimony of a doctor who will say that it is theoretically possible for a person to sleep drive. Sort of like sleepwalking, the defendant wants to claim that it is theoretically possible that sound asleep, he got in his car and drove. Now, the problem for the defendant was that he was also drunk. So if sleep driving is not a defense, he's going to be convicted of DUI. But he claims that if he did so while he was asleep, even though he was drunk, then he did not commit this act. And so the question the court has to ask is not whether this makes a fact more or less likely. The doctor is testifying that it is possible that sleep driving could happen. So the possibility of sleep driving goes up as a result of the doctor's testimony, or the doctor's testimony makes it more likely that the jury would find that sleep driving occurred in this case because they now learn it is a possibility. But the question is not that. The question is the second half of Rule 401. Is it a fact that is of consequence to the issue that sleep driving could have occurred? Does it matter at all that the defendant might have been drunk and asleep as opposed to just drunk and driving? If he's drunk and asleep, is that a defense to DUI? And as you'll learn when you read the case of State versus Newman, the court says yes. And they arrive at that conclusion from something that you learn first year in criminal law. With rare exceptions, a voluntary act is an unwritten requirement of most criminal statutes. So unlike things like failure to file your income tax that actually creates a crime of omission, DUI is like most every other crime, like murder or rape or robbery or burglary, that requires an affirmative voluntary act. So if he was asleep, he could not have committed that affirmative act of voluntarily driving a car while he was drunk. He did drive the car and he was drunk, but if he did not do so voluntarily, the court holds that would in fact exonerate him of this crime. So sleep driving is a fact that is of consequence, and that's what the court holds in State versus Newman. And so as you see here, you have to look at what the elements of the lawsuit are. What is it that the prosecution or the plaintiff has to prove? And we look there to determine what those facts are that are of consequence. What made it complicated in State versus Newman was the fact that when you looked at the DUI statute did not actually say, and by the way, you have to be awake. So the court had to look at what is implicit in this statute to determine which facts were at issue, and the voluntariness of the defendant's actions were in fact at issue and so therefore the possibility that he was asleep is an issue for the litigation, as the court then ruled in State versus Newman. And in our next video, we'll look at the next case, a Hawaii case, on whether the reason an officer pulls someone over for DUI is a fact at issue.